impelled by the application for leave to lead further evidence, which demonstrate that there is, in fact, quite apart from jurisdiction, a valid substantive defence to the claim. And we submit that apart from the amount in dispute, which is large, which is not of itself determinative, there is nothing special in the alleged creditor-debtor relationship that would constitute exceptional circumstances in the meantime. The learned judge, or Quo Davis J, seems to have found exceptional circumstances in the nature of the relief. In other words, he says, because it's not just a claim for a money judgment, and it's a claim for the enforcement of a session involving shareholders' rights, that's exceptional, and in the circumstances, exceptional circumstances are present. And we say with the utmost respect that that's a misdirection. It's not the nature of the relief that is the litmus test for whether or not there are exceptional circumstances. It's whether, in fact, there are exceptional circumstances based on the facts of the matter. And it has to be something other than the run-of-the-mill creditor/debtor relationship, because the default position is that an appeal suspends all of that. And very importantly, this is not a matter where there's simply a pending application for an appeal. The Supreme Court of Appeal has already granted the application for leave to appeal on the question of jurisdiction, and that Supreme Court of Appeal is pending. Now, the question of jurisdiction on its own is very significant because the authorities are quite clear that if an order is made by a court that does not have jurisdiction, then that order is a nullity. So we have the very real prospect that the Supreme Court of Appeal could agree with our clients on the question of jurisdiction, in which case they will find that the order by Davis J granting execution was a nullity. But in the meantime, if UIF has its way, that order will be executed in the meantime, and it will effectively render the Supreme Court of Appeal judgment moot. What the UIF effectively seeks to do by way of execution, notwithstanding the existence of reasonable prospects of success on jurisdiction, notwithstanding the existence of the Section 45 defence, notwithstanding the existence of further evidence which the UIF itself admits was in existence and is genuine, the UIF attempts to effect a hostile takeover of the debtor in the circumstances. And it doesn't take a great deal of imagination what could occur if that hostile takeover is permitted. What will occur is the following. UIF would be entitled to exercise the rights to appoint directors. And it says it wants to do that. That's the whole purpose why it wants execution. And once it's exercised those rights as a shareholder, it will appoint the entire board of HOMMI, which is the debtor. So we have this exceptional circumstance, and I emphasize this exceptional circumstance militates against the granting of execution in the meantime, that the creditor will control the debtor. Now, as I say, there's not much imagination that could be exercised to determine what could happen, and there is a very real prospect that this will happen. Firstly, the new directors could say that in the exercise of their fiduciary duty, they do not believe that there is any merit in the jurisdiction defence. They could also say, in the exercise of their fiduciary duty, in the genuine belief that this is so, that there is no merit in the Section 45 defence. They've gone on record, and they're represented by eminent counsel who have advised them that there are no merits in either of those defences. So it's not a question of whether they can be expected to exercise their fiduciary duty, and they won't exercise their fiduciary duty to engage in the feared conduct. On their own version, they are acting bona fide, and they have a genuine belief that there is no merit in these defences. So the new directors could very easily say, look, we don't think there's any merit, and we're abandoning the SCA appeal. They could also say there's no merit in the defences, and therefore we're causing the debtor to repay the creditor the money in the meantime. they could also say we're causing the debtor to go into liquidation in the meantime. So all of those would serve to deny our clients of their constitutional right of access to court to have determined by the Supreme Court of Appeal, pursuant to reasonable prospects, the appeal which is pending. So with respect, the execution that has been ordered by Davis J has potentially disastrous results for our client. And it's no answer for the UIF to say, well, these disastrous results are a mere mirage. They will never occur because the operation of the fiduciary duty of directors will prevent it from occurring. And as I've demonstrated, the directors could very well say they're complying with their fiduciary duty because they have no belief in the validity of the defenses. So one could only establish a breach of a fiduciary duty if one could show that the directors were exercising their duties mala fide and contrary to their genuine belief. So it's simply no answer. It's illusory to say that the harm that our client fears will not be suffered in the meantime, and it's prevented by the fiduciary duties. It's simply no answer. So we have a situation where execution has been ordered. There will be a hostile takeover. There are very real prospects that our client will suffer irreparable harm, and the execution with respect should not be maintained. And then that destroys, in our respectful submission, two fundamental pillars of what is required to satisfy this execution, the section for interim execution. I now turn to the third one. What irreparable harm will UIF suffer if the execution is not ordered? And again, with respect, they fail in this regard. They have not demonstrated any irreparable harm. They've taken a very long time to enforce their rights. And there's no sustainable evidence that demonstrates that in between the time of now and the Supreme Court of Appeal, they will suffer further or any irreparable harm whatsoever. So those in outline are our main submissions. And we respectfully submit that there would undoubtedly be a failure of justice in the circumstances if execution were to be ordered by this court in the meantime. The effect of our automatic right of appeal against the execution order is also that execution has been suspended in the meantime. But if this honourable court comes to the conclusion that our client's appeal should fail, then that suspension will no longer have any effect. That means that this court will, in effect, be ordering execution to take place pending the outcome of the Supreme Court of Appeal hearing. And if our client is right in relation to no jurisdiction, it calls into question the very status of this honourable court's decision. Because if there is no jurisdiction, then the decision by this honourable court allowing execution could also be a nullity. So what we have here is a recipe for further unnecessary complication and difficulty in the matter. With respect, the sensible solution is simply to await the outcome of the Supreme Court of Appeal hearing. If that needs to be expedited, then so be it. Our clients will have no objection to the SCA appeal being expedited and being heard as soon as possible. And that would alleviate any remaining fear that the UIF would have as regards what should happen in the meantime. Not that we submit that any such fear is well-founded to begin with. So that then brings us to the Section 45 defence. And there are two legs to the Section 45 defence. The one leg, that's the second leg, requires the introduction of new evidence, but the first leg does not. And the first leg is based simply on a point of law. We say that on the existing facts in the existing papers, the parties on both sides, and with respect Davis J, have missed the Section 45 point. And the Section 45 point is that under Section 45 of the 2008 Companies Act, financial assistance is prohibited unless that there has been compliance with the requirements for the giving of that financial assistance. Non-compliance renders the transactions, agreements in relation to the giving of that assistance void. So if we write, then the cession and pledge agreement relied upon and is which is the subject of the execution is void. The mezzanine facility agreement executed by HOMMI in favor of the UIF is void. And both of those follow from reasons that have been set out in our heads of argument. But before we get to that, we need to deal with whether it's permissible to raise a new point of law on appeal. And we submit that all the authorities...
That's why I come in, Mr. Harper.
Yes.
Your 10 minutes is up, so we patiently listen to you. Give us your main points. We would be interested in hearing you on the Section 45 point. That's the conditional application. You phrase it as an application to introduce new evidence. Isn't it correct, in actual fact, that this is a new defense? It's not new evidence. It's a new defense that you're bringing at this stage. Am I correct?
Yes, it's a new defense in two iterations, as it were. The first is it's in the iteration of a point of law. In other words, we say if a party comes to court and it's apparent on their own documents that they've missed a point, and the point of law is there based on their own facts, we submit that it's perfectly permissible to raise that as a new point of law, even if it amounts to a new defense.
Do you have authority for that, to raise such a defense at this stage of these proceedings, the circumscribed out of these proceedings? This is Section 18.4 appeal that's focusing mainly on a judgment that authorizes execution. And you want us to admit a defense that should have been raised even before the Section 18 hearing, before Davis J, but during the main hearing of the matter. That's when the defense should have been raised. It's not been raised throughout. And now that execution has been ordered, this point is being raised. Is it permissible? You say yes. I'm asking you, do you have authority for this?
Yes, Judge President, we've referred in paragraph 69 of our main heads of argument to the appellate division case of Paddock Motors versus Igesund, 1976, volume 3, SA 16, at paragraph 23F, where it holds that it would create an intolerable position if the court were to be precluded from giving the right decision on accepted facts, merely because a party failed to raise a legal point as a result of an error of law on his part. So that is the authority that we rely on. It might be different if there was some unfairness to the UIF and the PIC, but we say that there's no unfairness to them because the facts are already on the papers. And we say that whilst the ULI parties were in error in not recognizing you must have two requirements to render it not void. Firstly, you must have shareholders' consent, and secondly, you must have a resolution from the board of directors stating that immediately after providing the financial assistance, the company would satisfy the solvency and liquidity test, and the terms under which the financial assistance is proposed to be given are fair and reasonable to the company. And then subsection 6 reads as follows, quote, a resolution by the board of a company to provide financial assistance contemplated in subsection 2 or an agreement with respect to the provision of any such assistance is void, to the extent that the provision of such assistance would be inconsistent with this section. So what happens here is that the UIF presents these agreements for signature, and they do so on the basis of a take it or leave it situation. There's an unequal bargaining position. And if you want the loan, then you must agree to these conditions. And one of the conditions is that you will obtain security in the form of a guarantee and other security. And that guarantee then is squarely within the ambit of financial assistance as defined by the Act. And the Supreme Court of Appeal has held, as we've indicated, that we've given the reference to the loan agreement. It's at page 90, sorry, paragraph 92 onwards of our main heads of argument. And we say that if one looks at paragraph 99 of our heads of argument, clause 1.4 of the conditions precedent, schedule 1 to the mezzanine facility agreement, specifically makes section 45 compliance a condition precedent in the following terms. And then we quote paragraph 1.4, to the extent required by the Companies Act or other applicable law, and with reference to the constitutional documents of an obliger or a copy of a resolution, including without limitation all resolutions required in terms of section 44, 45, and 46 of the Companies Act, duly passed by the holders of issued shares, and 2, the directors of that obliger approving the terms of the transactions contemplated by the finance documents to which that obliger is a party. And that's why we say on their own documents on the mezzanine agreement, this was the source of the section 45 necessity in the first place. So they can hardly come to court and say, look, here's an agreement which sets this up as a condition precedent, and then they don't allege that the condition has been fulfilled. They should have done this at the outset. The original claim was acceptable, and this was missed with respect by all persons involved at that stage. And if it had been realized, the judgment by Davis J. with respect ought to have been that the mezzanine agreement, and in particular the cession of shares agreement, are all void for non-compliance with section 45. Because that's now well-established authority according to the Supreme Court of Appeal. So we say in the first iteration, we don't even need to get to evidence. The curiosity in this matter is that the UIF nowhere in their papers say that the Section 45 resolutions that we have put up as part of the application for leave to lead further evidence do not exist. They don't say that those documents are not in existence. They don't say that those documents are bogus. On the contrary, they say, well, yes, we did send you those documents, but those documents demonstrate that there was, in fact, Section 45 compliance. We have a different view on those documents, and we've put up evidence to that effect. And the evidence is that there was no valid shareholders' resolution because it wasn't a special resolution and it wasn't agreed to by all of the shareholders. And we also say that the directors' resolution that was passed did not satisfy the Section 45 test. And we put up evidence from the auditors to show that at the time of immediately after giving the financial assistance, the solvency and liquidity tests were not satisfied. So at a factual level, we say that with respect, there's no doubt that Section 45 was not complied with. So where does all of that leave us? It leaves us with this position that if we write and this court orders execution, A, we have the problem with nullity. I don't know where that will end up, quite frankly, because the authorities, and we've given an SCA case authority in our most recent heads, are very clear that if a court makes an order where there's no jurisdiction, the order is a nullity, and it can simply be not obeyed or ignored, because it's one of those exceptions to the normal rule that if you want to set aside an invalid judgment, you have to apply to set it aside. But this is a special category where there's no jurisdiction. A judgment can be a nullity and it can be ignored even if it's not set aside. It would be good form, of course, to apply to set it aside on the basis of rescission or some other basis. And we are presently pursuing that with the appeal. But we don't know what will happen if this court were to order, in effect, execution pending the outcome of the SCA appeal. It would create, quite frankly, some legal difficulties and uncertainties which are best avoided in the circumstances. So back to Section 45, we've set out the authorities that I've referred to previously at paragraph 85 onwards as regards what is required for Section 45 and what has been said by the Supreme Court of Appeal. The first is the commentary in Henoksburg, and the Henoksburg commentary is as follows. In relation to solvency and liquidity, the board must be satisfied that the company will satisfy the solvency and liquidity test. This appears to require that the board must not be satisfied that the company is solvent and liquid, but that it is satisfied that it will comply, in brackets, satisfy the test as in Section 4, which requires inter alia that the solvency and liquidity is based on reasonably foreseeable circumstances, which is not an absolute factual test. The board is satisfied means that the particular board is satisfied, which is a subjective test, but qualified by the objective, reasonably foreseeable circumstances. So we say that in relation to the fact here that the board got it wrong because all they did when they gave the resolution, the director's resolution, is they looked at the existing balance sheet. And they said, well, if you look at the existing balance sheet, there's solvency and liquidity. So we're happy to sign that the company has the requisite solvency and liquidity. But the problem is that that's not the test under Section 45, because Section 45 says that the time to determine that this is immediately after the giving of financial assistance. So in other words, what the board had to do was to imagine this. All right, we're giving the financial assistance now in the form of a guarantee, for example. And if the guarantee is called up tomorrow, which is the day after we give our assistance, can the company satisfy the indebtedness? And the answer to that is in the negative. And that's where the board went wrong on the evidence. So to repeat, not only is there no valid shareholders resolution, as is required by Section 45, but the board resolution was based on the wrong test. They did not consider the position immediately after the giving of financial assistance. And then the first case we referred to is in paragraph 87 of our heads of argument. That's the case to First Rand Bank versus Glasgow Trading. It's a 2015 decision. And the court there held that the suretyship in that particular case was void because it was in contravention of Section 45. And the Supreme Court of Appeal in the Constantia case that I referred to held the same. We referred to the Constantia decision in paragraph 89 of our heads of argument, and it is apparent there that the board must comply with the requirements, and according to the Supreme Court of Appeal, if the requirements are not complied with, the transaction is void. And what was argued in that case was the Turquand rule. In other words, the persons resisting the application of Section 45 came to court and they said, look, we are outsiders, we can't be expected to know the internal workings of the company, and therefore, if there was no compliance with Section 45 by virtue of the Turquand rule, that can't be held against us as outsiders. And the Supreme Court of Appeal rejected that. The Supreme Court of Appeal held that the Turquand rule does not save non-compliance with Section 45, and that a transaction contravening Section 45 is void. So where does that leave us? There are the two agreements, the mezzanine loan agreement. We've dealt with the mezzanine loan agreement from paragraph 92 of our heads of argument running through to paragraph 109. And we've dealt with the agreements which contravene Section 49 at the level of furnishing the financial assistance as well. So we say with respect that the Section 45 defense is a good defense. And it operates, as we say, at the two levels. Firstly, at the excipiability level against UIF, and secondly, at the foundational factual level, the existence of which facts are not disputed by UIF.
Mr. Hapa, you know, in this hearing, you've really elevated the Section 45 defense really high. And I don't know whether it would be unfair to ask you why it would have been regarded as not important by a previous legal counsel. Because that's the case that you're trying to be making, why this point was not raised before, isn't it?
It's correct, Judge.
If it kills the mezzanine agreement, as an example, and there was no non-compliance whatsoever, it would have been clear to say this is a point that has to be raised as a defense to this whole thing. Why then push it aside? I realize it may be unfair to ask you this question, but you've really elevated it and you're going deep into it and citing serious authority about why compliance with that section is important. And I'm asking myself, why was it regarded as nothing?
Yeah, Judge, with respect, it's a good question. There's a short answer and a long answer. The short answer is that mistakes happen in litigation, particularly in complex matters. The previous counsel engaged was focused on jurisdiction with some merit, obviously, because the Supreme Court of Appeal would not have granted leave to appeal if there was no reasonable prospect of the jurisdiction argument succeeding. Well,
don't be too certain about that. I I worked for 5 years, in fact for 7 years in that court. There are instances where after an appeal is heard, the judges ask, who the hell granted leave here? So
yes, I take the point, Judge President.
yes,
but we're not at that stage yet.
yes, yes.
And it brings us to another point. If I can just digress quickly there, and I'm going to come back to the long answer. The question is, what should this court do with the Section 45 defense? I mean, does this court have to decide the Section 45 defense? Yes or no? And with respect, I don't submit that this honourable court has to decide the Section 45 defense, because it's a situation that has to be taken into account as a defense. In other words, all we have to show is that there is a bona fide defense. Didn't believe that there was any bona fide defense to the action. If he thought that there was a bona fide and tribal issue, he should not have granted execution, but this was not drawn to his attention. So this court now is alive to the Section 45 defense. Should not be granted.
But Mr. Harper, sorry to come in there. On what basis can we say we can't decide the Section 45 point that the SCA decided? It's not before the SCA. You did say your clients are going to be making the same application there for this point to be heard. And you say correctly, Davis J wasn't alive to it when he granted execution, but he wasn't alive to it before that, isn't it?
Yes.
Fonset Origo, as they say.
Yeah.
How do we decide for the SCA to say you must decide the Section 45 point? Because those honorable justices still have to decide whether they allow that point, isn't it?
Yes, correct. But
yes.
Okay, if I can put it this way, Judge,
Yes.
What is before you now
Yes.
is not a decision to decide whether or not the debt is due.
Yeah.
What is before you now is a decision to decide whether to allow execution.
Yes.
On that debt.
Yes.
So it's not a question that you need to decide at this stage, the Section 45. And that's why we say all you need to say is that this is a defense that has now come to light that wasn't before Davis J, which if it had been placed before him would have materially influenced his decision in relation to execution. So you decide the execution point, not the validity of the defense per se, merely that there is a defense, which wasn't drawn to his attention. So I'm trying to draw that fine distinction, and I think with respect it's correct, because you're not the appeal court on the merits of the defense. Yes. It's not before you for that purpose. It's only before you for the purposes of the execution judgment. So to come back to the long answer, we have set this out in our application for leave to lead further evidence. The clients are obviously lay people. They rely on legal advice. And the legal advice at that stage focused only on the jurisdiction point. And they were of the view that that was the only point that was, in essence, or in issue in the case at that point. And the Section 45 point was unbeknown to them. So, as I've said in the short answer, mistakes happen.
Yes.
Americans like to refer to it as a mistrial on the basis of what previous counsel did. I'm not saying it was a mistrial. I'm simply saying that everyone missed the point.
Yeah.
It may not be necessary to get to that point. As I say, if previous counsel and clients are right on the jurisdiction point, we don't need to get there. But we say as a backup at this stage, it's undoubtedly a valid and material point that falls to be considered as regards whether or not there is a defense, because it fundamentally alters the whole nature of the judgment by Davis J, where he said, look, you're just raising a whole lot of technicalities. I disagree with you on the jurisdiction, and there's no substantive defense. Therefore, I'm granting execution. And it fundamentally influenced his entire approach to the matter. But this court, with respect, is in a superior position because it has the benefit of this point having now been raised and placed before the court.
Yes. And if we are to say this point was not previously raised when there was ample opportunity to raise it, and as far as we're concerned, it's not relevant for our current purposes, therefore we're not prepared to look at it. What's your answer to that?
Well, we would say that it's a fundamental failure of justice, Judge President, with the utmost respect.
Yes.
And again, we refer to the Paddock case where courts should not simply shut their eyes to justice. The courts are there to do justice. And it would be an intolerable position, to quote the Supreme Court of Appeal, if the court were to be precluded from giving the right decision on accepted facts merely because the party failed to raise the point as a result of an error on his part at an earlier stage. Courts do not generally operate in a manner where they simply shut their eyes to giving the right decision on accepted facts.
But would you agree that were we to go that route, it doesn't preclude the SCA from dealing with it? Does it? Because the SCA is dealing with the main case, basically, isn't it?
Yeah, it doesn't preclude the SCA from dealing with it, but it doesn't answer the question about whether there would be justice in the meantime in
Yes.
relation to execution.
Yes. No, I take your point there. Thanks.
So if I can turn now to the application in respect of further evidence. We have done separate heads of argument in that. And if I can refer the court to that, it's a conditional application, as I've indicated already. And it's based on Section 19(1)(b) of the Superior Courts Act. And the material provisions read as follows: the powers of the court on hearing of appeal. The Supreme Court of Appeal or a division exercising appeal jurisdiction may, in addition to any power as may specifically be provided for in any other law, and then one of the subcategories is receive further evidence. And the relevant factors according to the authorities are as follows. A, there should be some reasonably sufficient explanation based on allegations which may be true, while the evidence which is sought to lead was not led at the trial. B, there should be a prima facie likelihood of the truth of the evidence. And C, the evidence should be materially relevant to the outcome of the trial. And we deal with each of those factors in turn. The first is the conditional nature of the application, and I think I've already addressed that in my argument on the main heads of argument. I do emphasize, though, that in the application for leave to lead further evidence, annexes F1 to X6 comprise copies of the documents that were produced by the UIF and the PRC for signature prior to the signature of the session, including documents purportedly in compliance with Section 45. So at one level, this proves as correct the ULI party's point that compliance with Section 45 was required. Otherwise, why would the UIF produce documents requiring compliance with Section 45? It simply makes no sense to consider that even on the UIF's case, Section 45 compliance was required. The second level, however, involves a further inquiry as regards what was produced for that compliance and signed complied with the statutory requisites. And in fact, we submit that there was no such compliance for reasons I've already dealt with to some extent. So I turn now to the reason why it was not previously raised. And that's set out in paragraph 13 onwards of our heads of argument in relation to the application for leave to lead further evidence. The legal advice at the time was to concentrate only on the jurisdiction issue, as this was an application that firstly arose as a matter of urgency, and therefore the full merits were not dealt with. Secondly, when the ULI parties filed substantive papers, they were advised that the court could not find against them on jurisdiction, and in addition, they did not have to address the merits at that stage. Previous counsel involved in the matter was not alive to the Section 45 point, and accordingly it was not then raised. It was only when the ULI parties elected on or about 23 December 2024 to obtain further guidance from another counsel that the Section 45 point, as it applies to the present matter, was brought to the attention of the ULI parties. At that stage, the draft notice of appeal had already been formulated by existing counsel, and at that stage it was supplemented by the section dealing with Section 45. So the end of the long answer is that the ULI parties were not able to raise the point earlier because they were not alive to the point. And this lapse made by the ULI parties in good faith turned out to be incorrect, as Section 45 has a direct application in the present circumstances and should, in the interests of justice, be allowed to be dealt with. So we say that the first box has been ticked. There is an adequate explanation as regards why it was not previously raised. The second box to be ticked is that there should be a prima facie likelihood of the truth of the evidence. So we say that this is...
Mr. Harper, if I can
Yes.
just stop you there, if I can take you back to the reason for not introducing this evidence earlier. What I hear you to say, is it not simply saying we wish this court to allow this evidence now on appeal because we didn't think of introducing it earlier?
I think in broad terms, Judge Brunt, that is correct. But the underlying detail is we are dealing ultimately with lay people who rely on legal advice. And the person giving legal advice himself did not think of the point. And there was another point that was focused on, and there is merit in that other point. So it's simply an additional point. And in the circumstances, as I say, no one is ever going to be perfect in litigation. Mistakes happen. The law reports are replete with judgments that succeed on appeal, which could be considered to reflect mistakes of law or of fact that have occurred in the lower courts. So it's, with respect, not our law to demand perfection in relation to legal matters. And the law allows legal points to be introduced at a later stage if there is an adequate explanation. The law allows evidence to be introduced at a later stage if there is an adequate explanation, and there's a prima facie likelihood of the truth of the evidence, and there's a material relevance to the outcome of the trial. So there's no one simple answer with respect we submit to say, well, you didn't think of it previously and you can't raise it now. That's not the test. So moving on then to the prima facie likelihood of the truth of the evidence, I think I've already mentioned this. The ULI do not say that the documents that we put up under Section 45 are fake. They do not say they didn't produce those documents. They do not say that those documents were not signed. What they say is, yes, they agree. They did produce those documents. The documents are genuine, but the documents themselves comply with Section 45. Now, that's a whole different debate. At the level of ticking the second requirement, in other words, a prima facie likelihood of the truth of the evidence, that's undoubtedly established, because we've established that those documents are true and they were in existence, they were signed at the time. The rest is really a matter for legal argument. What is also critical is that UIF do not say that the evidence we have put up, the hard physical evidence from the accountants, to say that the Section 45 test was not satisfied. UIF do not say that that is incorrect. They put up no countervailing evidence. So again, in relation to that evidence, excuse me, there is at least a prima facie likelihood of the truth of that evidence. And in fact, as matters presently stand, it is unchallenged. UIF, if they wanted to challenge that evidence of the accountant, had every opportunity of putting up their own countervailing evidence to say the test was satisfied on the actual ground, as it were, on the actual figures, but they've elected not to do. So what must the court make of that? And we submit that, with respect, there's a fairly low bar there. We don't have to show that the evidence is conclusive. We have to show a prima facie likelihood of the truth of the evidence, and that has undoubtedly been met. The next requirement is the material relevance to the outcome of the trial, and we say that the Section 45 point is of crucial relevance, because if it is correct, this means that the UIF and the PIC have sued upon and obtained judgment on agreements which are void for non-compliance with the statute, namely Section 45. So we say it's undoubtedly correct that the requirement of material relevance to the outcome of the matter has been satisfied. Then in our heads of argument on this application, we deal in depth with the shareholders' resolution, and we deal with the director's resolution. And we say,
I think you've covered these parts, Mr. Harper.
Yes, Judge President, I'm quite happy to leave it at that and recommend a rereading, perhaps, of our heads of argument in that regard. We maintain all of those submissions, but I'm not going to delay the court by going through all of them again.
No, I'm just saying, in your earlier submissions, you did cover the shareholders' agreement part. In fact,
yes.
Yeah.
Yes, and the same for the director's resolution.
Yes, yes.
Johnson, as the sole director, believed that the ULI was adequately covered from a balance sheet perspective,
Yeah.
which is all that was considered by her, together with the apparent assurance by the UIF and the PIC by the presentation of the documents that all was in order. So that
Yeah.
was as far as the liquidity and solvency test went, and that failed the requisite standard.
Yeah. Are you able to take me to the Paddock case in your heads? Which heads? Is it the main heads, isn't it?
Sorry, the main heads that deals with what precisely, Judge President?
No, not main heads, where you deal with you rely on the Paddock case as your authority for bringing the Section 45 point.
Sorry, you rely on which case? The Supreme Court of Appeal case?
The Paddock case. You mentioned the Paddock case. I want you to take me to that case.
Oh, the Paddock case. Oh, sorry.
Yes, yes.
Yeah, it's in the main heads.
I think you said paragraph 16.
69, Judge.
69, President. Not 16, sorry.
No, 69. It's at page 17 of our main heads. That was also followed in the Bank of Lisbon and South Africa versus the Master and others, 1987-1, SA 276 at 290 D to I. It's in our footnote 4. on that same page. And also it was followed by Botha versus Smuts and another. It's a 2025 volume 1 Constitutional Court decision at paragraphs 56 to 69. So there are 2 Supreme Court of Appeal cases to that effect and 1 Constitutional Court case to that effect.
That follow Paddock?
Yes.
Okay, thank you.
Well, one Supreme Court of Appeal case follows Paddock, which was itself a Supreme Court of an appellate division case, as it was then called. And then the Constitutional Court case is the most recent one. It's a 2025 decision.
Yeah. And did you say the Constitutional Court as well?
Yes, that's Botha versus Smuts and another. It's 2025 volume 1 SA 581 CC at paragraphs 56 to 69.
Thank you.
So that brings me almost to my conclusion. I want to bring to the attention of the court, though, that in compliance with the practice directive, we did deliver further concise heads of argument. And in the process, I have referred to 2 additional cases. I've referred both of them to my learned friend, Mr. Wasserman, one last night and then one this morning. And the one case is a Constitutional Court case, which deals with quite extensively what constitutes exceptional circumstances. And one of the paragraphs deals with whether if there is going to be additional evidence, possibly, whether that could constitute an exceptional circumstance. And the Constitutional Court, albeit in a minority judgment, was of the view that the fact that there could be additional evidence granted to be led could constitute an exceptional circumstance. Now, why I'm dwelling on this is to reinforce the argument that I've made. A, there are no exceptional circumstances in favor of enforcing execution. And B, the exceptional circumstances operate the other way. There are, in fact, exceptional circumstances in favor of our clients to show that execution should not be granted in the interim. This is not to say that our client need to show exceptional circumstances to change the decision of Davis J. But it's simply within the ambit of what constitutes exceptional circumstances. So far from there being exceptional circumstances in favor of UIF, the existence of additional evidence on its own would destroy any exceptional circumstances favoring the UIF. The second case that I've referred to is Supreme Court of Appeal authority for the proposition that a judgment where there's no jurisdiction is a nullity and does not need to be set aside, even if it is on the basis that it's a nullity, because a court has no power to grant something if there is no jurisdiction. So it's a very important distinction, and that's with respect, somewhat difficult and dangerous territory we find ourselves in here, because if the Supreme Court of Appeal were to find that our client is correct that there's no jurisdiction, not only is the judgment of Davis J a nullity, but this court, which would effectively authorize execution pending the outcome of the SCA, would arguably constitute a nullity as well. So those are the unfortunate realities of the matter, which, in our respectful submission, compels the sensible and practical solution is simply not to allow execution pending the SCA appeal, and if it were possible to obtain some sort of direction that the SCA appeal be expedited, that might be the best solution even for the UIF. So in the circumstances, we respectfully submit that the appeal should succeed, and that in the process, our application to lead further evidence to the extent that it is necessary should be granted, and that the judgment authorizing execution should be set aside with costs in our client's favor, including the costs of senior counsel on scale C. So those are our submissions in the main.
Thank you, Mr. Harper. Just a general question. So if the Section 45 point is good, that means that it kills the mezzanine agreement and all other related agreements. So your clients keep the money.
Judge, it may be that, and I'm not UIF's legal advisor, thankfully, in this matter. It may be that they want to launch an enrichment action, which would have to be dealt with on its own terms. There would probably be illiquid counterclaims for damages caused by the UIF's conduct in the meantime. But the real point is this, that if there was an enrichment claim, it certainly could not include any contractual interest. So there's quite a complicated calculation to be done there, because payments have been made, presumably in respect of capital here. So whatever the amount is that might remain remains uncertain and illiquid at this stage. Secondly, it's not the basis upon which the execution has been granted. The execution here has been granted on strict contractual grounds.
Yes. And you say those contracts are out.
Those contracts are out. Yeah, we didn't.
What you say.
Yeah, Judge, my clients obviously didn't make up the legislation. The legislation is there in the wisdom of Parliament, and it's there for a good historical reason, is that this is a mischief that was sought to be addressed by way of our company law, that you can't have a situation where a related company gives financial assistance. And the aim behind Section 45, the purpose in this regard, is to protect the existing shareholders and to protect existing creditors, because they got there first in time and they have a vital and material interest. And that should not be imperiled by a company which is related to another company being required to give financial assistance that it cannot afford. And in this particular instance, it's a classic case for it, because the UIF set up the whole requirement in the first place. It made it a condition of its mezzanine loan agreement. You had to give this financial assistance, and the financial assistance was void. And the agreement itself, the obligationary agreement, is also void for non-compliance with Section 45 and for non-compliance with its own condition precedent. So that is the unfortunate reality that the UIF find themselves in. Whether they have another claim or not is something with respect beyond the scope of the present inquiry, which just deals with whether they're entitled to execution pending the SCA appeal on their existing course of action.
Yes. Thank you very much. Any questions, Judges Bernard? Okay. Thank you very much, Mr. Harper.
Thank you, Judge.
Let me invite Mr. Wasserman to address us.
Thank you. May it please the court. May I be as bold as stating that, having heard that the court has read the papers and you've heard my learned friend, and I've gained from the questions asked by the court that they're familiar with the issues, I don't mind if the 10-minute introduction is dispensed with. If you want to interrupt me from the beginning, please do so, because I think the issues have been crystallized. I want to start off by simply dealing with the first issue, my learned friend's concern that there might have been a mistake made by all the counsel before him and the judges before him. There were 3 judges. None of them raised the issue. The applicants before you were represented at some point by 2 different senior counsel, different parties, not raised. The judge hearing the matter, eminent judge of this division that we appear in, didn't think of raising it. And I must be as bold as saying that my junior and I also didn't think it is worthwhile raising that issue simply because it is not an issue. I identified two problems in my learned friend's introduction. The one is what he wants to do is introduce a new defense, an entirely new defense. It's not a question of introducing evidence to support an existing issue on the papers. It is an issue that is not on the papers that he wants to bolster. That is not permissible. It against the grain of authorities that we've listed in our heads of argument, it has been fully dealt with, and it simply can't be done. Secondly, his motivation for why it should be done is the very essence why it can't be allowed, and that is the mistakes made by previous counsel. That is the very reason why courts do not allow the introduction of new evidence. The authorities are clearly dealt with in our heads of argument, and that should put to bed the entire approach to introduce a new defense. But that is not where it ends, justices. This is a disingenuous defense. It is disingenuous because if you look at the application and the papers that were filed in the application papers, and I'd like you to make note of two references. It is the founding affidavit in the application to introduce new evidence, 37-12. That is the founding papers, and then the notice of appeal upon which reliance is placed and which is quoted in the finding papers, 37-44. May I limit my debate on this issue simply to the notice of appeal? There's a quotation in paragraph 17 of the notice of appeal, and you'll find the notice, that particular reference on 37-9. In paragraph 17 of the notice of appeal on that page, it seems to us the paragraphs have been incorrectly numbered, but it doesn't undermine the point that I'd like to make. In paragraph 54 in that quotation, that is on the next page, 37-11, and I want to read it to you. It reads, each of the agreements relied upon by the respondents for the purposes of the impugned order are agreements, inverted commas, with respect to the provision of any such assistance as contemplated by section 45. Obviously new, wasn't before any of the courts of quo, and it wasn't raised in any of the answering affidavits, because the answering affidavits never dealt with the merits. It raised 7 or 8 or 9 technical points, never dealt with the merits. And then the important part is 56.4 in that quotation. If you have a look at 37-12, the quoted paragraph 56.4, there is no shareholders resolution, nor any directors resolution as required by section 45 that is alleged by either the parties in the papers, and accordingly, they do not exist on the facts set out in the papers. The very same director that now boldly say to you that she's been represented by a set of documents for her signature in support and notice of motion, lifted from the founding papers in support of this application, stating, firstly, there were none such resolutions. Now, you hear in the founding papers, but we did nevertheless do some research and we found them. Here they are. If one has regard to my learned friend conceitedly referred to authority that the evidence should be credible, we submit the evidence before you is not credible. This is a farcical approach to introduce a defense who has got no merit at all. There are good reasons why the counsel in the matter before did not deem it advisable to deal with this issue, because it's simply a non-point. It is a non-point because, and may I start with my learned friend's bull point, that is the one premised on the so-called condition precedent. And he referred you to Paragraph 1.4, it's a quotation. It is in the heads of argument that he dealt with, and he quoted earlier. And I would, if you give me one moment, I will give you that paragraph. You'll find that justices at I was too quick to say I'm going to find it quickly, but you remember my learned colleague quoted paragraph, I think it was 1.4 from the mezzanine agreement. Let's stick to the mezzanine agreement. 1.4, the mezzanine agreement identified a condition precedent. Now, firstly, it is not for my learned friends, clients, to raise a condition precedent. It's a precedent for the benefit of the respondents before you, the party who gave the money. The money passed. Money was given. It's common cause. There can't be any talk of a condition precedent, non-compliance of a condition precedent at this late stage, late in the day. It's come and gone. It can't be raised. It's a non-point. And then secondly, the issue of the application of Section 45. It simply doesn't apply. And I want to venture, before I deal with the legal on it, I want to venture to say that the reason why this defense wasn't raised from the outset is because the deponent to the founding paper knew of the existence of these resolutions. It is inescapable that she must have known that she signed those documents. And she deliberately didn't introduce it because she knew there was compliance with Section 45 if it was required. That's the first point. The second point is this. Section 45 has a specific purpose. That is not to protect the shareholders of a company and the creditors of a company. Not to allow, I see it's tea time nearly, but if you would allow, no, it's not a warning, but it's tea time. No, there's enough time. The court will stop me if I need to stop.
Yes.
There's another 5 minutes. I'll carry on till you indicate to me that I have to stop.
That's fine.
Thank you, JP. The important issue is this. For the protection of shareholders and creditors, there ought to be compliance with certain requirements in order to make sure that the company has the viability financially to carry those additional demands financially. And the liquidity tests, etc., those are all specified in the Companies Act. But what is important is the relief that was granted and those the session and pledge agreements, documents upon which the relief before you has been premised, does not offend or impugn compliance with Section 45 because it's got nothing to do with 45. It doesn't burden the company financially. It is simply a cession of the shareholding from the holding entity to the respondents of this matter, which doesn't burden the urban lifestyle financially at all. It's got nothing. It doesn't burden its assets, doesn't demand from it to pay payments in future. It doesn't involve or import the application of Section 45 at all. Therefore, for good reason, the counsel that preceded my learned friend, who has raised this issue so late in the day, has deemed it inadvisable to raise that issue because it doesn't apply at all. And that should be the end of the Section 45 application. I would want to move over to the issue before you, the real issue before you, whether there should be interim implementation of the order. And
before you do that, Advocate Wasserman, I think as I pointed out to Advocate Harper, he really emphasized the importance of Section 45. He says there was non-compliance. You're saying, and in fact, what you've just said now, that the session and pledge agreements have nothing to do with Section 45. What about the mezzanine agreement?
Well, the mezzanine agreement is a self-standing agreement.
Yeah.
A document that it is from the debtor itself. The debtor itself signed that document. That document was implemented by both parties. That document is not covered by Section 45 because Section 45 pertains to related companies providing assistance, financial assistance to the debtor. So in the structure of Section 45, the mezzanine agreement is isolated, and the question posed by Justice Brunt wasn't really addressed. It is clearly a document not covered by the Section 45 requirements. Why my learned friend argued that it is also struck is premised on the ill-advised reliance on the so-called condition precedent. So he lifted from the document itself a condition precedent that said, voila, there was no compliance, therefore also this document is struck. He didn't really apply premise that submission on the application of Section 45. And the reference I was looking for, clause 4.1, is paragraph 99 of the heads. I'd like to see 99 of those heads. If you dealing with the condition precedent, and that you will see starts off properly so, to the extent required by the Companies Act or other applicable law. So to the extent required by the Act. This is one of those set of documents that simply do not apply at all. The cession and pledge agreement pertaining to the shares, it's got nothing to do with a cession and pledge of assets, allowing a creditor to attach those assets to execute. It doesn't provide financial assistance. So therefore, even my learned friend's construction of a condition precedent simply holds no water.
Mr. De Beer, could you just give us are these the main heads of the appellants?
Just in front, this is lifted from the main heads, and it's 43-44 is the 44. We'll find that quotation.
I think it's important that maybe you just slowly read clause 99 that you've referred us to for us to get the gist of your argument.
Thank you. JP, I accept that what my learned friend is doing, lifting from the set of conditions precedent in paragraph 19, and he's quoting 1.4 thereof, and it starts off, to the extent required by the Companies Act or other applicable law, and with reference to constitutional documents of an obliger, a copy of, I don't know what that, maybe not a correct quotation. And the next page, resolution, including without limitation, badly quoted, all resolutions required in terms of sections 44, 45, and 46 of the Companies Act duly passed by 1, the holders of the issued shares, and 2, the directors of the obliger approving the terms of and the transactions contemplated by the finance documents to which that obliger is a party. So it's simply a provision stating that if Section 45 has application, if the related company provides financial assistance, then I want, as the creditor, I want those documents. I want copies of the resolution of the shareholders, and I want a copy of the resolution of the board. That's all it says as a condition precedent. Now, that obviously entitles the fund in terms of the mezzanine agreement to say, I'm not allowing this money to flow because there is non-compliance with a condition precedent. But it is within its own right to determine whether there was compliance or whether there wasn't compliance, and to allow the funds to flow. Once the funds have been allowed to flow to the debtor, the purpose of that entire precondition has been fulfilled. It doesn't have any significance anymore. That's a simple point I wanted to make. So there is no substance in the submission of our learned friends that the mezzanine agreement is void because of non-compliance with that particular condition precedent.
Thank you very much. Would this be a convenient time to take the break?
It would. Thank you, Jody.
Thank you very much. We will adjourn then for 15 minutes and resume at what's the time now, Clement? Clement? Okay, I think let's resume in 15 minutes time from now.
Sorry, JP, I was muted there for a second. It's 19 past 11.
So 15 minutes thereafter, what time is it? Does it give you?
33, if I'm not mistaken.
Oh, give us another minute, 34. Okay.
Okay.
Thank you very much. Court adjourns.
Court pleases.
Advocate Wasserman, are you here?
We've been here the whole time, but the operator was not available to get us online.
Good. Sorry, I'm the reason we're starting late. I'm taking this hearing from the Joburg High Court, and I had to justify that to the DJP here. And he made sure I come back to this hearing late. So I apologize for that. Mr. Wasserman, yeah, please continue.
No, please, the court. There are two issues that I'd like to just complete before I move on to the implementation appeal, and that concerns the reliance placed by my learned friend on the paddock matter that JPU referred to. Paddock obviously is that kind of case where everything is before the court and uncontested and indicative of a legal issue, supportive of a legal issue. That's not the case here. The case here is something entirely different. To make the Section 45 argument, one will have to have regard to the facts which were never developed or adduced at the quote unquote. And for that authority, the actual correct authority is the one we refer to in paragraph 19 of our heads of argument in the application for leave to introduce further evidence on appeal. Footnote 19 is the case of Yanako versus Apollo Club 1974 1SA 614A at 623G-H, which simply emphasized the principle that when illegality is raised, the party burdened with the onus has to introduce the evidence, has to establish the facts upon which that illegality will be premised, and has to prove those facts. And that applies in all cases where the illegality is not evident from the document itself. The nullity is not from the document itself. And here, the mezzanine agreement, as well as the cession and pledge agreement, there's nothing in the document itself that demonstrates or supports the notion of illegality or nullity. So my learned friend's premise on paddock is simply not applicable in this case. If I may move over to the three elements, the one of exceptionality, exceptional circumstances, the other of harm for the appellants or harm for the respondent.
Before you move there, Mr. Wasserman, the first question I asked Mr. Harper was, in a sense, the raising of this Section 45 issue is more the raising of a defense than of introducing new evidence. And I think Mr. Harper conceded to that point, but to say it's a very relevant issue to take consideration of. I want your attitude. You've been making submissions to the effect that it's not applicable. You've just referred to the fact that the mezzanine agreement and the cession agreements, the facts around them have not been set out sufficiently to fall into the paddock realm. Now, what is your attitude to the Section 45 issue as raised? The application is to introduce new evidence. That's what it is. But I asked Mr. Harper the question that it's actually not evidence, but a defense. What's your attitude to this? What do you regard this as?
The whole attempt is to introduce an entirely new defense, which was never ventilated in the quote unquote. That defense, evidence in support of an existing defense evident from the material before the quo, would be permissible if it's credible, if it's not contested, because it's a court of appeal. And the reason why it shouldn't be contested is if there's no room in a court of appeal to entertain disputes concerning factual issues. And those two elements are not present here. They purport to introduce as evidentiary material the FA 3 and 4, the two resolutions pertaining to shareholders and to the board. Now that we've dealt with fully in the heads of argument. Even if you accept and you allow the introduction, those documents actually demonstrate the opposite. It demonstrates that there was compliance with Section 45. In order to come to the conclusion that there was not compliance on Mr. Harper's argument, you'll have to entertain the factual disputes, which can't be dealt with in the Court of Appeal, because there's a debate whether the sole shareholder was the A1 Capital Company, or whether at the time of the resolution, at that date, there was already a transfer or registration of ownership of the 40% shareholder in the fund. That is not dealt with at all in the material before you, and that contested evidence can't be resolved in a court of appeal. So the whole notion of introducing the additional evidence to support a new defense is simply not tolerated in the scheme of an appeal hearing. And it's not contemplated in Section 90 or 92, my learned friend referred to. And what we've done is we've identified in paragraph 17 from a recent Supreme Court of Appeal judgment, the IBEX RSA matter versus Black Star Group. In paragraph 17, all the elements of appeal will need to be present before the court would even consider allowing new evidence or additional material, factual material, into the record. None of those requirements in section 7, paragraph 17 that we've dealt with in our heads of argument have been met. It's simply, especially if I could just ask you to have regard to 17.3 in that set of heads, and that reads, it is permissible to alter one's legal strategy on appeal by introducing a new defense. It's not permissible to alter one's legal strategy on appeal by introducing a new defense disguised as further evidence. That's precisely what's happened here, and precisely contradictory to the principles enunciated in IBEX. And that particular page you'll find in the case lines on 43-74. So that's the answer I have, JP, to the proposition that Mr. Harper was asked to deal with as well.
Thank you very much.
I think he may have considered that it is a new defense. That in itself is fatal. But what we say is even the introduction of new material disguised as a new defense is not permissible. Just in conclusion, Mr. Harper indicated to you that there will be two defenses on the merits. One is the defense on 45 on appeal, and the other concerns jurisdiction. And you referred to the case uploaded last night or this morning, the Tetelex case. And if I may just say one thing in regard to that matter, if you would bear with me, it is the Travelex Limited versus Sean Maloney matter that my learned colleague caused to be uploaded. And I would ask you just to focus on paragraph 26 of that judgment, from which one is able to discern that the case is not applicable to the facts in Kazu. All the respondents before you are inquili of the division of this court. And my learned friend's argument, I do not know precisely how he plans to develop that, is that there was no other grounds for jurisdiction other than the consent to jurisdiction. That's simply not the case applicable to the findings that were made by, firstly, Judge Strader. Well, only Justice Stradum dealt with jurisdiction. And his jurisdictional concern was not an absence of jurisdiction, it's simply a pleading issue, because he didn't allow it to be raised in the replying affidavit. The point my learned colleague is now trying to introduce was never before the court at the time when those urgent applications were dealt. And that's also the finding of the judge, Aquo, in this matter, that it was a technical issue, a pleading issue that was raised, not a decision based on the facts. May I then deal with, firstly, exceptional circumstances? Now, we've given you the authorities as to the meaning of that expression. I don't think there need to be a debate about it. I'm just simply trying to demonstrate that this is a very extraordinary case. If one starts with the parties, this is not a creditor debtor like my learned friend really tried to introduce. It's quite clear what the fund was doing here. The fund is a stakeholder. The fund invests monies that are being used to carry unemployed people, people that need money when in the case of unemployment or in the case of losing their jobs. Those are public funds earmarked specifically for a particular sector of the community in need of that financial support. What the UIF business is to partake and to become stakeholders in investments, in this case, a property development company, and that funding that was granted was allowed, and if one looks at the contract, an extraordinary contract, where there is no capital repayment for a period of 15 years. The only thing the applicants or the appellants had to do is to regularly pay the interest. That's all it had to do. Two things: pay the interest and give us information. Why the information? That information that was contractually provided for, to ensure that the UIF as a stakeholder in the developments are kept abreast, or is kept abreast of the proper application of those funds, and to take timely steps to protect those investments should those funds not be properly allocated and applied. Now, you've seen the ducking and diving for a period of 2-3 years where the appellants were not prepared to provide the evidence and the material. You've seen the meetings in the documents, and where there was an application made for a defrayment of the payment obligation to provide it extra time, but not once was there compliance by furnishing the financial information pertaining to those investments. And hence the suspicion that the interest payments that had to be made quarterly were misused, were not applied properly in the sense of paying back. Obviously, it was misused because it was applied differently, not in respect of repayment of the either the allocation to the interest and the investments of HOMMI itself, but the serious concern that those funds were deflected to other companies in the group for which it was not permitted. And hence the persistence on the part of the PIC and the fund to get information from HOMMI in this regard, not forthcoming. So we have a relationship which is more than a debtor-creditor. We have a stakeholder in the investments of these property developments. And we have furthermore a relief that is not focused on winding up or the demise of the creditor. It is focused on saving the creditor. That information is sought in order to make sure that the agreement to apply the funds properly is being maintained and complied with. And that we submit. If we look at the relief that is being sought, namely an implementation that is aimed at protecting and saving the debtor or the others, if I may use the expression in inverted commas, the partner in these projects. It's not a typical creditor claiming for its satisfaction of its debt and seeking its money. This is a fund in the form or the nature of a partner who wants to make sure that the investment is sound, that it's properly maintained, and that the funds earmarked for the projects are not being misused. And we say those are exceptional circumstances, warranting the implementation of the order pending the appeal. Why do we say the relief is relevant? Because the relief is not, as my learned colleague has argued, seeking to bring an end to HOMMI. That's quite the opposite. The evidence is quite clear. The board is to be replaced not to seek a winding up of HOMMI or to frustrate the litigation that's pending. And the court is invited to make, if it makes the order, to add conditions to that order. My client is committed not to frustrate the appeal, not to abuse the funding in order to allocate the proceeds to anything other than the business of HOMMI, and if it's possible from the proceeds of the company to settle the interest payments. But predominantly it is to make sure that the funds of HOMMI are not being misused. That's the purpose of the relief that's being sought. Now, why do we say it's exceptional? Because you've never seen it before. I've never seen it. I'm sure no court has ever seen this kind of relief, where it's not a takeover, it's simply a board from independent people stepping into the shoes of the existing board in order to make sure that the company is properly run. And it's in need of proper governance at the moment. It's obvious from the papers that there is a lack of proper governance. So we say one places all these facts in one pot. There can't be an escape from the conclusion that this is exceptional and it warrants the court's interference as far as 18.4 is concerned. Then there are only two elements remain. The one is the harm for HOMMI. I'll park that for a moment. But the harm for the fund, it's quite clear that the harm is ongoing. As long as the proceeds of these developments are being misallocated to other projects, the obligation of HOMMI to settle its interest payments is being frustrated and undermined. And that harm will be addressed if an independent board is seeking proper governance once it's taken over the responsibilities of HOMMI. But as far as HOMMI's concerns are concerned, my learned friend raised red flags, winding up, frustration of the appeal, taking the money in settlement of HOMMI's debts. That's an easy one with respect, because that's not the purpose of the relief that's being sought. The fund is on record, the POC is on record as to what the purpose of the relief being sought is, and we submit that it's quite within the court's jurisdiction if it allows the invitation to accept the invitation from my clients, the PIC and the fund, to make specific directives as to the non-interruption of whatever litigation may be outstanding, not frustrating whatever litigation is still outstanding, and not using the proceeds of these developments at the expense of HOMMI's own interests. Those conditions we're quite happy to live with. And we submit there is simply no basis for our learned friends' concerns about the so-called red flags of undermining HOMMI's prospects of being a viable entity. If those three elements are present, then there may be, and there is conflicting authority on this point. If one looks at the case law that we've dealt with, if one has regard to the DJP's judgment in Incubeta in Johannesburg, you will see that that judgment seems to be premised on the understanding that the discretion of the court as to the prospects of success on appeal is not a relevant issue. But if one looks at Knoop, the judgment by Justice Wallace in Knoop, and I could maybe just spend a minute or two on that if you would allow me. That issue, I think, is not settled yet. And the SCA in that judgment, if I could ask you just to make a note of the following, and I'm going to, I don't have the case before me on case line, but I will give you the paragraph numbers in the Knoop judgment. If one has regard to paragraph 49 of that judgment, as read with 50, if 49, and if one remembers the facts of this case, because they came to a finding that there was non-compliance with 18.4 and the implementation will not be allowed, the appeal was upheld. It was not necessary for the court to concern itself with the prospects of success on appeal. But there are judgments, and referred to in this judgment, that dealt with the prospects of success on appeal in the scenario of a Section 18.4 application. In 49, the court says, in Justice Alliance, that's the name of the judgment, it was held that the court has a wide discretion to grant or refuse an execution order once the statutory requirements are satisfied. We submit those requirements are satisfied. And that prospects of success in the appeal have a role to play in considering the exercise of that discretion. Therefore, there is a dictum in UFS versus AfriForum that supports that approach. But in both that case and in Klemeza, the record in the main appeal was not before this court, and the appeals had perforce to be decided without the full court or any consideration of the merits in the main appeals. So that's a predicament in this kind of appeal, because the record is not ordinarily available at the time when the application is made. We had the full record in the main appeal before us and had read it in anticipation of dealing with the main appeal, but the argument on the urgent appeal did not include any debate over prospects of success in the main appeal. And the judge then carries on and says, this may be an issue that to be determined still. But assuming that once the three elements have been satisfied, and the court, this court, is entitled to look at the prospects of success and has a wide discretion, we would urge for that approach, because it seems that there is authority for the proposition in the SCA that the court sitting with an issue like this, dealing with an issue like this, has a wide discretion to consider the prospects of success. And for that reason, I made reference to the fact that there are only technical defenses before the SCA. There are no defenses on the merits. And the only one that seemed to be of some import is the one of jurisdiction, which wasn't the one raised by my learned friend. It's simply a pleading issue that was raised and dealt with by the judge Aqua. So we say if that is added to the respondents' bundle of issues that the respondents are permitted to advance before you, we would urge you to take into account the prospects of success, because we would submit there is no hope for the appellants to seek positive relief in the SCA. Simply no hope, because there is simply no pleading or no allegation supporting any defense on merits in all the papers before you and the papers that will be ventilated in the Supreme Court of Appeal. And that we submit is probably the strongest point we have, and we would urge you to have regard to that submission. Those are our submissions, unless there are further issues you would wish me to deal with, but that, I think, caters for all the arguments we wanted to add before.
So you say paddock doesn't apply because the factual scenario there and here is different. And you say Section 45 is not relevant.
I submit so, yeah.
I see. Okay. Any questions from Justices Brand and Barnard? None. Okay, no problem. Thank you very much. Mr. Harper, you ready to answer?
Yes, Judge, I'm ready.
Please go ahead.
Judge, dealing firstly with Paddock, my learned friend says Paddock doesn't apply, and he refers to the Yannico case. The Yannico case is completely inapplicable because there it dealt with the question of pleading, and it says you have to plead an illegality. And this is not a case of an illegality. This is a case where the statute says you must do certain things, otherwise the agreement is void. So the two cases are completely distinguishable. In any event, it doesn't help them to refer to a case dealing with pleading. The issue here is whether you are entitled to raise a point of law which amounts to a new defense in two iterations. The first iteration is where you're not going beyond the papers.
Yes.
The second iteration is where you are going beyond the papers. On the first iteration, the authorities are very clear that you can raise a point of law even if it amounts to a new defense, if you are limited only to what's in the papers and there's no prejudice to the other side. And we've given the authorities for that. Yannico has nothing to do with that, quite frankly. It's quite clear that we fall within the first iteration because on their own version, there's a provision in the mezzanine agreement which requires Section 45. They attempt to say Section 45 was not applicable at all. Well, if they say that, that begs the question as regards why they, on the facts, put up Section 45 documents to be signed in the first place. There's no sensible answer to that. Why would UIF itself put up Section 45 documents to be signed if Section 45 had no application whatsoever? The second reason why he says Section 45, or submits why Section 45 doesn't apply, is because it doesn't apply to a cession agreement. But with respect, that goes against the express wording of Section 45, which specifically includes, as part of what constitutes financial assistance, the securing of any debt. And this was a cession in securitatem debiti. So it falls directly within the ambit of what constitutes financial assistance and is hit by Section 45. Thirdly, he submits that, well, this clause regarding Section 45 was simply for the benefit of UIF, and implicitly it could be waived by them. Well, firstly, it wasn't for the benefit of UIF, plainly not. The section provides that the protection is for the company that is giving financial assistance, and in order to protect the shareholders of that company and its creditors. So it's not for the assistance of UIF. If my learned friend is correct, Section 45 wouldn't find application at all because lenders could simply specify, well, Section 45 is only for my benefit and therefore there was not to be any compliance. With respect, that would be an absurd conclusion. Thirdly, there's no suggestion in the papers that Section 45 compliance was waived. On the contrary, the papers make it clear that the UIF sought to comply with Section 45 by producing Section 45 resolutions for signature. So on the clear wording of the statute, Section 45 obviously does apply. Now, in relation to the secondary point made by my learned friend, he says, oh, well, there's no money actually being given here. It was just a cession of shares in securitatum debiti. But that is contrary to the direct wording of Section 45, as I've already submitted. B, it's a particularly severe form of financial assistance, because what you have here is the person giving the cession, namely Uli, is prejudicing its own shareholders and its own creditors by disposing of potentially a major asset of Uli, which is the shareholding in HOMMI. And it's putting that entire shareholding at risk by providing security. In other words, the security can be realized if the mezzanine agreement is not honored and the obligations thereunder are not paid. So it's a particularly severe form of financial assistance. It's probably an even more extreme form of financial assistance than the mere furnishing of a guarantee, because it amounts potentially to the disposition of a major asset. And we know that HOMMI was wholly owned by Uli. So it's a very valuable asset that's been disposed of by way of this security, potentially. And that's the reason, after all, why Uli wanted the security comprised by that shareholding in the first place. It wouldn't have asked for that unless it was valuable. And it wouldn't have given the money unless that security had been provided. So on the first point, I've answered in relation to Paddock. It clearly applies. We can raise this point either on the papers themselves or by way of the admission of further evidence. As I understand my learned friend's submission quite correctly, he does not say you can never introduce further evidence. He does not say you can never introduce a new legal point which raises a new defense. He says, as I understand him quite correctly, that the general rule is you can't, but under particular circumstances you can. And those are the circumstances that we have addressed in our application, believed to lead further evidence. In other words, there's a sufficient explanation. The evidence is prima facie to be regarded as true. And thirdly, that it's undoubtedly material. But we don't need any of those requirements in relation to the first iteration of when we can raise a new defense on appeal. In relation to the first iteration, I must emphasize the only requirement we need to have is firstly that the facts are already there on the papers, and they are on their own documents. We can see the requirement for Section 45. And secondly, that there's no prejudice to them by raising it. And there's no sustainable prejudice that they have been able to contend for. They haven't said that if we'd raised it earlier, they would have had a defense or an answer that they no longer have. So it doesn't matter that the defense and the new legal point on their own papers was raised at this late stage. It may affect the question of costs, but that's as far as it would go. It's not an absolute bar at all to us raising the new legal point, even if it amounts to a new defense. So the next point raised by our learned friend is he deals with the case that we refer to on jurisdiction, and he says that this is not applicable because it's fact-bound, it's fact-specific, and there's no point of principle that emerges from that case. This is the SCA case on the question of jurisdiction, and the authority of the SCA that a judgment made without jurisdiction is ineffective and null and void. But with respect, what is submitted is not correct. It is a point of principle. It wasn't simply fact-bound on the facts of that case dealing with an incular, and that has been uploaded into case file. And I will, with respect, refer to the particular paragraphs in that case which are relevant. And the first one is paragraph 11. Paragraph 12. where there's a reference to the decision by Ponner and J.A. in the Master of the High Court, North Gauteng Court, Pretoria versus Matala, N.O. and others, where Ponner and J. said the following, quote, as long ago as 1883, Connor J. C.J. stated in Willis versus Corbin, 4 NLR 97 at 98-99, quote, the general rule seems to be that a judgment without jurisdiction in the judge pronouncing it is ineffectual and null. So this is a very long-standing principle, going back to a clear expression in 1883, which has been expressly approved by our Supreme Court of Appeal. And then in paragraph 13 of that same judgment, there is a reference to the Constitutional Court decision in MEC versus Health, Eastern Cape, and another versus Kirkland Investments. And the Constitutional Court affirmed the following approach. It referred to the decision in the Master of the High Court versus Matala and others with approval. It said the Supreme Court of Appeal reaffirmed a line of cases more than a century old, which held that judicial decisions issued without jurisdiction or without the citation of the necessary parties are nullities that a later court may refuse to enforce, in brackets, without the need for a formal setting aside by a court of equal standing. This seems to be paradoxical, but it is not. The court, as the fount of legality, has the means itself to assert the dividing line between what is lawful and not lawful. For the court itself to disclaim a preceding court order that is a nullity, therefore does not risk disorder or self-help. And that is directly applicable to the present circumstances, where this court is entitled to say that there is at least a prima facie basis for saying that the decision by Davis J. is a nullity, and the Supreme Court of Appeal may well find that. And that may be said without any necessity for a formal setting aside by a court of appeal or a court of equal standing of the decision of Davis J. So it's a decision that this court can make or reach at this stage of the proceedings. So it is a point of general principle emerging from that case. And the case I referred to is Travelex Limited versus Maloney. And B, it is directly applicable to the present circumstances, notwithstanding the fact that the parties there were talking about Inkler and no jurisdiction. You can have many bases for saying that jurisdiction is not there. And we don't say that this involves Peregrini or Inkler, but we say that jurisdiction is not there on another basis, which I'll get to in more detail in a little while, because that has also been directly challenged by our learned friends. The next point that our learned friends deal with is some sort of sympathy argument as far as we can see. They refer to the fact that there are public funds in the UIF. They complain that there has been, quote, ducking and diving. They say there's a suspicion that interest payments are not being made for various reasons. So they say, well, you know, some sort of special treatment is deserving now for the UIF. If that's their conclusion, with respect, it's not correct. The UIF cannot claim to be a special category of contractual litigant, and the UIF cannot claim to be immune from the reach of Section 45. Further, with respect, we join issue with the allegations as regards ducking and diving. The situation has been explained in the papers at some length. There's no basis for suggesting that the interest payments are being reallocated for some or other bad reason, and there needs to be some sort of anti-dissipation interdict granted. They've never applied for an anti-dissipation interdict, and they cannot use execution as some sort of surrogate for an anti-dissipation situation. They're either entitled to execution or they're not. Then they say, well, the relief is important because the relief renders exceptional circumstances applicable. And again, we say not true. And I've dealt with that in my main submissions. They say, well, they're not aiming to seek a winding up. They're not aiming to seek that the litigation be dispensed with. And they invite the court to add conditions. Well, that's problematic. Firstly, because it's never been canvassed in the evidence. It's now raised for the first time on appeal, and we object to that. Secondly, they don't say how the court is going to impose conditions and who the conditions are to operate on. What will happen here on execution, if it's allowed, is that the UIF will appoint all of the directors of HOMMI. And it's not the UIF that will make decisions that can adversely affect our clients. It's the new directors. And these new directors are not before the court. They haven't been joined. They haven't even been appointed. So we don't know how it is suggested that conditions can be attached that would safeguard our clients in the circumstances. We don't know how the court can be expected in advance to set conditions upon directors who haven't yet been appointed and who may well have other ideas. It's with respect an impractical and incorrect suggestion. The court is not there to run companies. Otherwise, it would not have time to do judicial work. So this is a vague suggestion made as a last resort, which simply does not have any merit. So the dangers remain. We don't know what these new directors will say. There are obvious dangers in the circumstances, and in the circumstances, there's no valid basis for a continuation of execution in the meantime, or a resumption of execution pending the SCA appeal. No basis has been made for any prejudice that would be suffered by the relatively short interregnum that will follow the decision of this court and the hearing of the SCA appeal. Our learned friend then refers to the decision of KNURP. KNURP, as far as we can see, is a decision of the Supreme Court of Appeal that has nothing to do with the present circumstances. It talks about whether the court is empowered to order that a suspension will not operate pending an appeal, but it was fact-specific in relation to the circumstances involving a potential or actual removal of the business rescue practitioners. So we are unable to find any principle there of general application that would apply here, apart from the fact that Section 18.4 is referred to and dealt with on the facts of that particular case. But it doesn't assist. If anything, it supports what we say regarding an order having been made without jurisdiction constituting a nullity, because that is clearly, again, emphasized in KNURP that this is the situation. And then the final point of attack by our learned friend is to say that the jurisdiction issue was raised only as a pleading issue and that there's no allegation on the papers made by our clients in relation to the substantive lack of jurisdiction. With respect, that's not correct. And in our concise heads in reply, we've identified the specific portions of the record that raised the substantive defense in relation to a lack of jurisdiction. And if I can take the court to the main one in that regard, if the court will indulge me in that regard, I can just find that place in the record. Yeah, the debate has to do ultimately with the terms and conditions of the documents. What happened was, if I can just trace the history briefly before giving the reference, it was initially a pleading issue, and it came up before Judge Stradom. and he held that the applicant, i.e. the UIF, had not demonstrated jurisdiction of the Pretoria court on the papers. And that was the basis of his judgment, which is in the papers. Then the papers were expanded, and what the UIF said was, no, that was not correct, and here are additional facts, additional evidence. And according to the UIF, there were clauses in the agreements that rendered jurisdiction applicable in Johannesburg. And it was to that our clients responded at pages 632 and 633 of the papers in particular. And in paragraph 52 of that affidavit, our clients drew attention to clause 1.2.2 of the HOMMI Lifestyle Session Agreement, which states that the HOMMI Lifestyle Session Agreement, in the case of any conflict with the provisions of the mezzanine agreement, that the HOMMI Lifestyle Session Agreement would prevail. Quote, the provisions of this agreement shall prevail. And then they drew attention to clause 30.1 of the HOMMI Lifestyle Session Agreement, which states that the cedent hereby irrevocably and unconditionally consents and submits to the jurisdiction of the Gauteng Local Division, Johannesburg, of the High Court. So the background to this was that UIF had instituted proceedings in the Pretoria Division against the respondents who all had their registered offices within KwaZulu-Natal, within the jurisdiction of the KwaZulu-Natal Local Division, Durban. But UIF says, no, but there's a provision in the mezzanine agreement that says you consenting to the jurisdiction of the Pretoria court. But the mezzanine agreement only applied between the UIF and HOMMI. It didn't apply to Uli, the party against whom the session agreement was sought to be enforced. And if you look at the session agreement, to sum up, the session agreement prevails, and the session agreement says that it's the Johannesburg court that consent is given to, not the Pretoria court. Then there's a debate in the papers as regards whether the fact that there is some degree of concurrent jurisdiction between the Pretoria High Court and the Johannesburg court affects the matter. In other words, if there's a consent to jurisdiction to the Johannesburg High Court, is that still a consent to jurisdiction to the Pretoria court? And that's the issue that is going to the Supreme Court of Appeal. It's not simply a question of pleading. It started off as such, but then it developed in the papers, and it's now a substantial issue as regards what the agreements say, where our clients' registered offices are, and whether there is a saving by virtue of concurrent jurisdiction, which means that a consent to the Johannesburg High Court is also a consent to the Pretoria High Court. Those are the issues. What's also at stake are the provisions of, I think it's section 21 of the High Court Act that says if you've got jurisdiction against one person, you can sometimes include another person. It also involves the causa continentii doctrine, which runs along the same lines. So there are very substantial issues to be determined before the Supreme Court of Appeal, and it's a substantial issue. It's not a pleading issue on its own. So those are the points that we make with the utmost respect in response to those made by our learned friends. If I may just have a moment to look at our concise heads of argument to see whether we've covered everything we wanted to say and reply. Sorry, Judge President, might I go off screen for a moment, because I do have my instructing attorney with me in chambers, and I need to just double check with him whether there's any other point he wishes to raise.
That's fine, as long as you mute yourself. We don't want to hear them.
Thank you. I will do so. Thank you, Judge President. I am back.
Yes.
Judge, just 2 points. Firstly, my striking attorney points out to me that when it suits UIF, they link the mezzanine agreement with the session agreement. In other words, for jurisdiction, they say, oh, well, in the mezzanine agreement, there's a consent to jurisdiction of the Pretoria High Court. And I've dealt with that's, with respect, not a valid argument. But then, on the other hand, when it comes to Section 45, they attempt to separate the mezzanine agreement from the session agreement, and they say that they're two self-standing agreements. With respect, the correct position is that the mezzanine agreement is the source and the fonts of the non-compliance with Section 45 in the first place. It set up the mischief, which was hit by Section 45, and the result is that all of the agreements, if we are correct on the Section 45 point, are hit by Section 45 and they are void. The second point is this, and I'm not sure that it was suggested by our learned friends in their argument, but there seems to be some sense that perhaps they said that if their directors take control under execution, that they will then cause payment to be made of the interest in the meantime, pending the SCA appeal. Now, if that's what they said, or what they meant to say, that demonstrates the fear of our concerns, because they would then be getting the new directors to make payment in respect of interest, which are not due, because the agreements on our version and defence are void, and no interest should be paid pursuant to them. So those are the final 2 points. Our submissions remain, with the utmost respect, that the appeal should succeed with costs.
Thank you very much, Mr. Harper. Any question, Judges Brandt and Barnett? You okay?
Nothing. Thank you, JP.
Thank you very much. We understand the importance and perhaps some urgency as to the decision we need to come up with, but we are going to reserve our judgment, and then it will, once our judgment is ready, it will be published in the usual way and made available to the parties. I take this opportunity to thank both sets of legal teams for their assistance in ensuring that the elucidation of the points in this matter are as they were expressed. So thank you very much in that regard. As I said, judgment is reserved. Court is adjourned. Thank you.
As the court pleases.
As the court pleases.